Welcome to episode 2 of the Zech Support Legal Studies series. Today's episode covers one of the most fundamental principles in criminal law, Actus Reus, the Guilty Act. By the end of the episode, you will understand what Actus Reus is and why it's required for criminal liability, the difference between voluntary and involuntary acts in criminal cases, how failure to act can be a crime under specific legal duties, landmark cases that define Actus Reus in modern law. This episode is packed with legal insights, real cases, and practical applications. So let's dive in. What is Actus Reus? Actus Reus is one of 4 essential elements of a crime. Number 1, Actus Reus, the physical act of committing the crime. Number 2, mens rea, the mental state or intent behind the act. Number 3, causation. The act must cause harm or a criminal result. Number 4, concurrence. The guilty act and intent must exist at the same time. California Penal Code Section 20 states, in every crime or public offense, there must exist a union or joint operation of act and intent. In short, you cannot be convicted of a crime unless you physically do something or fail to act when legally required. Let's break down voluntary versus involuntary acts. For a defendant to be guilty, their action must be voluntary. If an act is involuntary, there is no actus reus and no crime can occur. California Penal Code 26 states that people cannot be held criminally liable if their act was involuntary. Here's an example of a voluntary act. Let's say that Sandra aims a gun at Tony and pulls the trigger. Blackout! She chose to take action. Her act is voluntary, meaning Actus Reus is present. But how about an example of an involuntary act? Let's say that Thomas has a seizure while driving and loses control of his car and kills a pedestrian. Thomas had no control over his actions, so Actus Reus is not present. Now let's look at real court cases that shape this principle. Looking at the landmark case in Ray David W., 1981, here are the facts. David was intoxicated in his home and causing a disturbance. His brother restrained him until police arrived. Officers handcuffed David and took him outside. He was charged under California Penal Code 647F for public intoxication. The legal issue: was David voluntarily in a public place when arrested? The court's holding: no, David did not voluntarily enter the public place. The police forced him there. Because his movement was involuntary, he could not be guilty under Penal Code 647F. The takeaway is that criminal liability requires a voluntary act. If the state forces you into an illegal situation, you are not guilty. Here's another landmark case, People v. Ross, 2008. The facts of the case: a woman was arrested and taken to jail. Before entering, she denied having a weapon. A search revealed a knife hidden in her clothing. She was charged under California Penal Code 4574A for bringing a deadly weapon into a jail facility. The legal issue: if she was brought to jail against her will, did she voluntarily bring the weapon inside? The court's holding: yes, even though she was taken to jail involuntarily, she had a chance to declare the weapon and chose to lie. Lying about the weapon was a voluntary act, making her criminally liable. The main takeaway is that a person's initial presence in a place may be involuntary, but their subsequent choices and actions can still be voluntary. Can failure to act be a crime? Yes, but only when the law imposes a legal duty to act. These are 5 situations where failing to act can result in criminal liability. Number 1, a statute requires action. For example, child neglect laws. Number 2, a special relationship exists. Example, parents must protect their children. People v. Beardsley, 1907. Number 3, a contract imposes a duty. Example, a lifeguard must save drowning swimmers. Number 4, someone voluntarily assumes care. Example, if you start helping, you must continue to help. Number 5, creating a risk of harm. Example, if you cause the danger, you must try to prevent the harm. Here is a landmark case on omissions. People versus Oliver, 1989. The facts of the case. A woman brought an intoxicated man home, saw him inject heroin, and left him unattended. The man overdosed and died. She was charged with manslaughter for failing to seek help. The court's holding. By taking the man into her home, she assumed responsibility for his safety. Her failure to act made her criminally liable. The takeaway here is that if you take control of a situation, you may be legally required to prevent harm. Now we're going to use some Latin terms. Corpus delicti. Confession alone is not enough. Under corpus delicti doctrine, a confession alone cannot convict a person. There must be independent evidence that a crime actually occurred. For example, if a suspect confesses to burning down a house for insurance fraud, if there's no evidence that the house burned, the confession isn't enough for a conviction. The final takeaways. Actus Reus requires a voluntary act or a legal duty to act. Involuntary acts like seizures do not result in criminal liability. Failure to act is only a crime when a legal duty exists, and confessions alone are not enough to convict a person. Criminal law isn't just about what you think, it's about what you do. Your actions or lack thereof determine criminal liability. That's it for today's episode. Until next time, stay informed, stay curious, stay on the right side of the law, and remember, when you need help, you can always call Zech Support.